So there's a decision in the Liebowitz Usherson v. Bandshell case. The court's going to go over all the facts, but this is the case where Liebowitz was sanctioned by Judge Jesse Furman in a very long summary decision that I covered last summer. The judge wanted Liebowitz to notify all of his courts and notify all of his clients and pay $100,000 plus in sanctions, and Liebowitz challenged this to the Second Circuit Court of Appeals. And this is the decision where Liebowitz loses that appeal. So let's go over what the court has to say about losing the appeal, and then I'm going to go over the facts because the court fills in a lot of the gaps in this story. And then we're not going to go over the law because it's a very long decision. It's 55 pages. So I've highlighted out what we're going to read, and I think this will be entertaining as a story of how not to be a lawyer. Look at how many times he had a chance to correct the situation and not make a big deal out of it. I always say, eat crow while the crow is young and tender, or else surely you will eat it when it's old and tough. Much easier to correct a mistake early on than it is to double down and deny that you made a mistake and turn it into a situation where you're accused of lying to the court. Richard Liebowitz and his firm, the Liebowitz Law Firm, appeal from an opinion and order of the district court sanctioning them for their conduct during their representation of Arthur Usherson in his copyright case against Bandshell Artist Management. Liebowitz repeatedly violated court orders, lied under oath to the district court, and brought and maintained this case in bad faith. The district court imposed monetary sanctions of $83,517.49 in attorney's fees, $20,000 in additional monetary sanctions, and non-monetary sanctions that, among other things, imposed nationwide requirements on cases filed by Liebowitz or LLF. We, the appeals court, hold that the district court did not abuse its discretion in doing so. The district judge's factual findings, including the findings of bad faith, were adequately supported by the evidence in the record and by the district court's judgments of witness credibility. Given these findings, the sanctions imposed by the district court, while strict, were not an abuse of discretion. Accordingly, the order of the court is affirmed. And this is Chief Judge Livingston and Circuit Judges Wesley and Carney, a 3-judge panel. Livingston writes, Richard Liebowitz has been a member of the bar for a short time. In that time, he has compiled an ignominious record of reprimands and sanctions from judges across the country. This appeal concerns one such sanctions order. The U.S. District Court for the Southern District of New York, Judge Jesse Furman presiding, determined that Liebowitz brought and maintained a copyright infringement action in bad faith, that he violated multiple court orders along the way, and that when questioned about his conduct, Liebowitz repeatedly lied to the court, including under oath. Citing Federal Rule of Civil Procedure 16 and 28 U.S.C. 1927 and the court's inherent powers, the district court imposed sanctions, as we said, of over $100,000 in additional monetary sanctions. Judge Furman also imposed non-monetary sanctions. This appeal arises out of an action filed by appellants on behalf of Usherson on July 10, 2019. The complaint alleges that Bandshell Artist Management infringed on Usherson's copyright for a photograph of musician Leon Redbone, and that at the time the complaint was filed, the photograph was registered with the Copyright Office. In reality, the photograph was not registered. Moreover, Usherson had provided Liebowitz with a CD-ROM containing the photographs registered pursuant to the registration before the complaint was filed, and this CD-ROM did not contain the photograph. Sometime after July 10th, the date the complaint was filed, Usherson sent Liebowitz another CD-ROM containing photographs he had not yet registered. This collection included the photograph. The firm then proceeded to register the photographs on the second CD-ROM on August 22nd, 2019. Unaware that the photograph had not yet been registered, the district court issued 2 orders, July 15, 2019. Liebowitz complied with none of these orders. The filing of proof of service was untimely, appellants failed to produce the required discovery, and they failed to participate in the mediation by the required date. Instead, 1 week after the deadline for mediation had passed, Liebowitz filed a letter suggesting the mediation had not taken place because of the mediation office's failure to assign a mediator. He requested leave to hold a telephonic mediation. In an order dated October 7, 2019, the district court criticized Liebowitz for his attempt to blame the mediation office for his failure to meet the mediation deadline, but concluded that mediation was still potentially valuable. The parties agreed to a mediation. On October 31st, however, neither Liebowitz nor his client, Usherson, appeared. Instead, 2 associates from Liebowitz law firm, neither of whom had entered an appearance in the case, were sent in Leibowitz's place. The lead associate, James Freeman, later informed the district court in a sworn declaration that Liebowitz had apprised him of the existence of the matter only the night before. The second associate was Leibowitz's sister, a newly admitted lawyer, attending only to shadow Freeman and learn about the process. No agreement was reached at the mediation, a result that the mediator later attributed in part to the failure of Liebowitz and Usherson to attend. Banshell moved for sanctions. Banshell charged Liebowitz and Usherson with violating the court's orders regarding the mediation, pre-mediation discovery, and proof of service, and sought monetary sanctions and dismissal of the case. Liebowitz first addressed the mediation controversy in a joint letter filed by the parties before the initial pretrial conference. In this letter, Liebowitz claimed that he and Usherson had received permission from the mediator not to appear in person. But in the same letter, Newberg indicated on behalf of Banshell that virtually everything in plaintiff's statement is false, and that Newberg had warned plaintiff against filing a false statement regarding the scheduled mediation with the court. Liebowitz nevertheless repeated the claim in a letter response to the sanctions motion that his client had received permission from the mediator for Usherson's telephonic appearance, and in addition, that the mediator was aware that Liebowitz too would not appear. Specifically, the letter represented that his client had obtained permission from the assigned mediator to appear by telephone provided that counsel was present in person, and that Liebowitz had informed the mediator that an LLF associate with knowledge of the facts of the case would appear in person, and the mediator consented. At the November 14th pretrial conference, Liebowitz, appearing as principal trial counsel, stuck by this story, stating that the mediator had given permission for Usherson to appear by telephone. The district court, aware of proceedings before another Southern District judge in which Leibowitz's candor to the court had that very week been seriously called into question, specifically warned Liebowitz that he should be very careful about the representations you make to me. The court then inquired when Liebowitz had informed the mediator that Usherson would not appear in person. Liebowitz answered, "I don't know the exact date, but it was before the mediation," and he said yes. On further inquiry from the court, Liebowitz also made clear that he had personally advised the mediator by telephone that Usherson would not appear in person, and that the mediator said that was okay. Freeman, who was also present, stated that he had learned about the case only the night before the scheduled mediation, and that he had no knowledge as to whether any approvals had been secured for telephonic appearance. At the same pretrial conference, Newberg also inquired whether the photograph had been registered before the lawsuit was filed, as the complaint alleged. Banshell had learned that Usherson had filed a copyright registration, apparently for the photograph, after the complaint was filed, suggesting that the photograph had not been registered before. If the photograph, in fact, was not registered when the complaint was filed, particularly in light of Judge Furman's decision in a Malibu media case, this could have required dismissal of the action. Banshell requested discovery on the potentially dispositive issue of whether the 046 registration referenced in the complaint actually covered the photograph. In response, Liebowitz obfuscated, replying, "I don't know what defense counsel means about other registrations or other photographs. I will have to see what my office did, but this is the correct registration." He argued against limited discovery on the registration issue, urging the court to let proceedings continue in the normal course in the hope of getting to a settlement number. So he's interested in settling more than he is investigating the registration issue. Telling, isn't it? After the conference, Liebowitz was ordered to file a formal opposition to the sanctions motion. This order included an instruction for both sides to address whether an evidentiary hearing should be held, and if so, what form it should take. Leibowitz's formal opposition disregarded this instruction, but it once again repeated the claim that Liebowitz had received permission for Usherson to appear by telephone from the mediator, and that the mediator had consented to Leibowitz's plan to have an associate appear in Leibowitz's place. Liebowitz submitted a sworn declaration affirming that he sought and received approval from the assigned mediator for Usherson to attend the mediation via telephone, and for my associate James Freeman to appear, who had full knowledge of the case. I obtained the mediator's consent via telephone. In response, Newberg, Banshell's counsel, defense counsel, submitted a declaration citing to emails from the night before the mediation that suggested that both Banshell and the mediator were under the impression that Usherson and Liebowitz would be appearing in person the next day. Specifically, Newberg emailed the moderator the night before the scheduled mediation, sending along a proposed agreement and affirming that Usherson could accept the agreement, or we will see Mr. Liebowitz and Mr. Usherson tomorrow, and we can continue discussing the possibility of settlement at the mediation. Later that same evening, the mediator replied affirming that he had spoken to Liebowitz, who said he would review the agreement and get back to them in the morning. The mediator further stated, hopefully we can settle this before the need to go to in-person mediation. Newberg responded that he would be catching an early train to attend the mediation and assumed Liebowitz, who had been in California, was already in New York or would be catching a very early plane. The mediator responded, I understand. In addition, Liebowitz himself was in email communication with Newberg early in the morning of October 31st, but at no time notified Newberg that neither he nor Usherson would be attending the mediation in person. Further, Newberg attested that he called the mediator on November 19th, a few days after the pretrial conference. The mediator informed him that on previous occasions he had allowed Leibowitz's clients to appear by telephone, but maintained that he had not given approval for telephonic appearance in this case. According to Newberg, the mediator told him that Liebowitz had called on the night of October 30th and informed him, without asking for approval, that Liebowitz was out of town and that an associate would be attending the mediation. Usherson's attendance was not discussed. The district court ordered the mediator to file a declaration, which he did. In his declaration, which is under penalty of perjury, the mediator stated that he had spoken to Liebowitz by telephone on October 30th. During this call, Liebowitz did not inform him that an associate, rather than Liebowitz, would be appearing the next day. The mediator denied that he had given permission for Usherson to appear by telephone. The mediator did note, however, that Liebowitz had sent an associate in his stead on at least one other occasion, and that his clients had appeared by telephone in other mediations conducted by the mediator without incident. So, in practicality, it sounds like Liebowitz just made the mistake of assuming that what had happened before would be okay in the future. I've made this mistake, but when I made the mistake and I was confronted by the bankruptcy trustee, because I used to represent people in bankruptcies, I admitted I was wrong. I said I was sorry, that I had made an assumption. And that was the end of it. I got a slap on the wrist, just a verbal lashing from the bankruptcy trustee, and then we continued with the thing like normal. If there was to be a monetary sanction, it would have been a small one. If Liebowitz had simply ate crow while the crow was young and tender, he would not be facing a $100,000 plus sanction and all the non-monetary sanctions as well. Liebowitz thereafter filed a letter on December 16th asserting that he contested statements made by the mediator in his declaration, and that Liebowitz had notified the mediator that Mr. Usherson would be appearing telephonically and that such a request was granted. The district court concluded that an evidentiary hearing was necessary. On December 17th, the court issued an order scheduling the hearing. 2 days later, Liebowitz filed a stipulation of voluntary dismissal, signed by both parties. The parties agree that the case should be dismissed with prejudice, which means the case is extinguished, can't be brought again, and that each side would bear its costs and attorney's fees. In a letter filed that same day, Newberg affirmed that Banshell had stipulated to Usherson's withdrawal of the case with prejudice, but that neither Newberg nor his client would have done so, except for the fact that his firm was representing Banshell pro bono. So, Newberg very graciously represented Banshell pro bono, which sort of enabled Liebowitz to pull out without having to pay the defense. However, the court picked up the ball and ran with it then. The district court so ordered the dismissal, but retained jurisdiction in order to adjudicate the motion for sanctions and related matters. The evidentiary hearing was held on January 8th, 2020. The district court treated the witnesses' declarations as their direct testimony. Additionally, it appeared Leibowitz's application to expand the record to include a new argument that the mediator's custom and practice of allowing Leibowitz's clients to appear telephonically caused Liebowitz to harbor a good faith belief that he had the requisite permission and could have caused the mediator to forget whether in fact he granted permission in the case. Liebowitz was permitted to testify about 5 previous cases in which he claimed the mediator had given him oral permission to have his clients appear by telephone. He also added that in one case he had been given permission to have an associate appear in his stead. But Liebowitz also admitted on cross that in one of these very cases, he himself had objected to another party appearing telephonically on the ground that the mediation rules require in-person appearance, thus evidencing his understanding that permission was required. Regarding the present controversy, Liebowitz testified that he had called the mediator around 7:30 to 8 p.m. the night before the scheduled mediation and received permission both for Usherson to appear by telephone and for Freeman to appear as counsel. He made no written record of the call. In other words, attorneys are supposed to take notes. We don't have to, but it helps to take notes when you do something, especially if it's time billed to the client. So they're saying here he made no written record of the call. When asked how he now remembered the date of the call when he did not at the November 14th pretrial conference only 2 weeks after the event, Liebowitz testified that the emails attached to Newberg's initial declaration in support of Banshell's sanctions motion had reminded him. When pressed on the fact that Newberg's declaration and the annexed emails were actually filed before the November 14th conference and that Liebowitz had responded to them in writing, he simply declared that, "I often forget things." Liebowitz claimed during his testimony that he had a contingency plan if the mediator had denied his request for Usherson to participate by phone and Freeman to take Leibowitz's place. At the time of the call with the mediator, Liebowitz was in Los Angeles hosting a networking event, and Usherson was at home in Georgia. Despite never booking flights or even checking the flight times, Liebowitz claimed he was prepared to return to New York immediately. He did not claim to have informed Usherson about the potential need to immediately travel, but testified that he was sure he could have called Usherson and knew that he's always around. Leibowitz's testimony was notably at odds with the statements made by his own associate, Freeman, to the effect that Freeman had only learned of the existence of the case the night before the scheduled mediation. Liebowitz claimed to the contrary that the two had spoken about the case on numerous occasions. Liebowitz also claimed in his testimony that he had informed Freeman about the approvals given by the mediator, notwithstanding Freeman's statement at the pretrial conference to the contrary. As to this later discrepancy, Liebowitz sounded a similar theme, suggesting that people forget things and that Freeman had done so. Liebowitz also asserted that Freeman properly appeared at the mediation because he was the lead attorney in the matter, even though it was Liebowitz who appeared as principal trial counsel at the pretrial conference, and indeed Freeman had not entered an appearance in the case. Newberg and the mediator also testified. Newberg testified that he remembered the mediator saying at the mediation that he had been notified that Liebowitz would be sending an associate. Newberg also recalled the mediator stating that he expected Usherson to attend in person. For his part, the mediator testified that he could not then recall whether Liebowitz had informed him that Freeman would be appearing. He did acknowledge that prior to the mediation, he had learned that Liebowitz was in Los Angeles and that, as a result, it was unlikely he would attend in person. The mediator testified unequivocally, however, that he did not give permission for Usherson to appear by telephone, despite speaking with Liebowitz several times on October 30th, the day before the mediation. He learned that Usherson would not be coming only when the mediation started. After the testimony, the district court heard oral argument. During argument, Bandshell revealed that it had discovered the photograph had indeed not been registered prior to the filing of the complaint. In response, Freeman stated that it was the regular practice of Liebowitz law firm to file copyright infringement cases without verifying the registration of the works in question to avoid expense. The firm instead took clients at their word that the works in question were properly registered. Freeman stated that in this case, Usherson had affirmed that the photograph was registered. The district court ordered an additional round of letter briefing on this issue. In his letter, Liebowitz admitted that the statement in the complaint regarding the registration of the photo was inaccurate, but he also noted that his firm had registered the photograph in August 2019, and he blamed the inaccuracy in the complaint on an administrative mistake or clerical error in the copyright registration process. In response, Bandshell contended that this explanation defied belief, as Liebowitz at the initial pretrial conference had denied any knowledge of other registrations or other photographs, affirming that the 046 registration referenced in the complaint was correct. The district court ordered Liebowitz, Freeman, and Usherson to submit declarations addressing the circumstances surrounding the inaccurate allegation about the registration of the photograph. The reason the court requires these declarations is to put things on the record under penalty of perjury so that you can be bound to those statements as under penalty of perjury. Liebowitz admitted in his declaration that he had conducted no investigation into the matter. This was despite Usherson's statement that he had sent the firm a CD-ROM prior to the filing of the complaint, which included all the photographs that had been registered pursuant to the registration identified in the complaint. Usherson admitted that he had made a mistake in advising Liebowitz that the photograph was registered as part of the 046 registration. Liebowitz claimed that he had relied on the firm's internal case tracking system and that he had no role in filing for the photograph's registration in August 2019. He asserted that he did not realize the photograph was not properly registered until after the sanctions hearing in January 2020. The district court entered the order sanctioning Liebowitz and the firm on June 26, 2020. The court found that sanctions were warranted for Leibowitz's conduct. The district court found that Liebowitz violated no fewer than 6 of the court's orders. Judge Furman further concluded that these violations were willful. The district court found that Liebowitz repeatedly lied to the court, including under oath, about receiving permission for Usherson to appear by telephone in the mediation, citing, among other things, Leibowitz's demeanor at the evidentiary hearing, the conflicts between Leibowitz's testimony and that of Newberg and the mediator, both of whom the court found credible, and the documentary evidence. The district court found by clear and convincing evidence that Leibowitz had not only made false statements to the court, but had done so in subjective bad faith. Finally, the district court concluded, by clear and convincing evidence, that Leibowitz brought and maintained the case in bad faith by willfully disregarding the fact that the photograph was not properly registered at the time the complaint was filed. Judge Furman concluded that Leibowitz knew the photograph was not properly registered at least as of August 22, 2019, when his firm registered the photograph. In any event, he should have known and had failed to conduct a reasonable investigation of his client's statements. The district court turned to the question of sanctions. It determined attorney's fees were an appropriate measure of sanctions, though Bandshell, represented by pro bono counsel, had disclaimed the right to collect any fees. Judge Furman concluded that $83,500 was an appropriate fee for the work Bandshell's lawyers performed in connection with the mediation and the sanctions motion, and that the sum would be payable to the court. Second, Judge Furman ordered Leibowitz and the firm to pay an additional sanction of $20,000 to the court for falsely alleging in the complaint that the photograph was registered and for not conducting a reasonable investigation either before the lawsuit was filed or after they were put on notice of the potential defect in their pleadings. The district court imposed non-monetary sanctions. The first of these sanctions required Leibowitz to serve a copy of the order on Usherson and every other current client of Leibowitz. He and Leibowitz's law firm were further required to file the order on the docket of each of their pending cases and any case they brought within a year of the order's entry. The second sanction required, for a period of 1 year, that complaints filed by Leibowitz and the firm involving claims of copyright infringement include a copy of the deposit files maintained by the U.S. Copyright Office showing the registration of the relevant copyrighted work or works involved in the case. Finally, the district court sent a copy of the order to the Southern District's grievance committee so it could consider whether further discipline was appropriate. The district court included with the order an extensive appendix of, I think it was 40 previous cases from a number of jurisdictions in which Liebowitz was reprimanded or sanctioned for misconduct. District courts have inherent statutory and rule-based powers to sanction lawyers for conduct that impedes the efficient administration of justice. Indeed, we, the Second Circuit, have said that district judges have an obligation to act to protect the public, adversaries, and judicial resources from litigants and lawyers who show themselves to be serial abusers of the judicial system. We review the imposition of sanctions for abuse of discretion. To be sure, because sanctions proceedings are unique, placing the district judge in the role of accuser, fact finder, and sentencing judge all in one, our review is more exacting or scrutinous than under the ordinary abuse of discretion standard. Moreover, depending on the circumstances, a party facing sanctions may be entitled to enhanced procedural protections associated with criminal procedure, beyond just notice and an opportunity to be heard. Here, we conclude that the sanctions imposed by Judge Furman on Liebowitz and the firm were well within the scope of the district court's discretion. Accordingly, we affirm the order of the district court. The court then goes on for another 30 pages explaining why each decision the court made was reasonable, and I don't think that that's very helpful or interesting. It's just going to be a fact-by-fact examination of whether there was evidence to support it. The conclusion is there was evidence to support it. The court then concludes, given Leibowitz's serious and repeated misconduct, the appellants here merited sanctions reserved for attorneys and litigants who demonstrate via their actions that unusual measures are required to deter future misbehavior, to protect other litigants, and to maintain the integrity of the judicial system. Leibowitz's brief time as a member of the bar so far has been replete with actions suggesting an unwillingness to comply with his obligations as an officer of the court. The district court did not abuse its discretion in determining that sanctions were appropriate and imposing the sanctions here. For the foregoing reasons, we affirm the order of the district court. So, Liebowitz still has a right to appeal that to the Supreme Court. I'm going to go out on a limb and say that he's not going to do that. I don't think it would be a very good idea to put something like this in front of the Supreme Court, let alone that I think it would be an expensive process. Filing things in front of the Supreme Court is kind of expensive. I think I heard somewhere around $20,000, $30,000 just to file something before the Supreme Court because of the various requirements, especially printing requirements they have. You need to have something like many copies, 23 copies or something like that, and those copies are on a weird format in a weird size of paper. And I don't know if any of that's changed. It sounds like an access to justice issue to me, but I doubt that the Supreme Court would grant certiorari. So I think this is the last we've heard on the Usherson v. Banshell appeal. I don't know if Judge Furman will enter any concluding orders, maybe the judgment or something against Liebowitz. It's not a judgment, it would be a final sanctions order or something. Either way, Liebowitz now owes over $100,000 to the Southern District of New York, which I believe he's been suspended from the practice of law in the Southern District of New York, so that means he's not able to directly represent clients in that district before that court. So the Liebowitz saga is ongoing. We will continue to follow the various cases, not the least of which is the Bradley v. Analytical Grammar case, which is coming to its conclusion. That should also be an interesting one. We did a video on that sanctions motion or attorney's fees motion, so we'll have an update for you when that comes out. Let me know what you think of Liebowitz in the comments below. And that's today's video. Special thanks to our top supporters in July: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Torpedan, Brandyn, Abel, ShadowTycho, RDHDragon, Earthbound Star, and PureMagma. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye. Liebowitz's testimony was notably at odds with the statements made by his own associate,